Welcome to Immigration Review, your weekly source for immigration case law updates and insights. I'm your host, Kevin A. Gregg, back again to review the week's precedential immigration cases, rummaging through the decisions so you don't have to. This podcast is sponsored by Kurzban, Tetzeli, and Pratt, also known as KKTP, a law firm where I'm also a partner. Whether you are facing an immigration obstacle, a serious injury, or a legal issue in your business, KKTP will aggressively protect your best interests. This podcast is also sponsored by Cerenade e-immigration. In a time of change and uncertainty, e-immigration's case management system and dedicated team are here to help you keep calm in the chaos. Talk directly with the award-winning e-immigration team to see how their software can help you manage your cases, clients, forms, and firm with ease. Get a personal demo at get.eimmigration.com/demo or click on the link in the show notes. And of course, mention Immigration Review Podcast on your demo for a special offer. And as always, this show does not constitute legal advice and has no bias other than to keep you up to date and to enable you, my dear colleagues, to excel in court. So, without further ado, let's start the review. Big news this week on the Alien Enemies Act, with the district court judge in Texas permanently blocking the Trump administration from removing alleged gang members from Venezuela under the 1798 Alien Enemies Act, ruling that the gang's activities in the United States cannot be regarded as an invasion. So says Law 360 at least. And you don't say. Laughable premise, always, this invasion nonsense. But it doesn't mean that the government won't win the day eventually. Who knows? Good on the court for focusing on the law. Trump appointee, no less. My heart continues to break for all of those already swept up in the madness who were never part of any of these gangs anyway. Also, the U.S. government has asked the Supreme Court to weigh in on the temporary protected status issue, or at a minimum, a judge's ability to grant nationwide preliminary relief. The fate of like 1 million TPSers potentially rests in the hands of 5 justices, preliminarily. 4 cases this week, and if you, like some other attorneys already, have strong feelings about my Middle-earth immigration query from last week, don't be shy. Hit me up. I'll defend my dwarf theory through the third age and beyond. First up is Mayancela Guaman et al. V. Bondi, published by the First Circuit on April 28, 2025. This is a very long one, about asylum. And like the First Circuit, I quote, warn that the facts underlying Ms. Mayancela and Mr. Santander's petition, which we draw from the administrative record, including petitioner's testimonies, which the IJ found credible, are quite grim, end quote. The case is about a family, with the lead applicant being the mother, Ms. Mayancela. They're all indigenous individuals from Ecuador. Growing up and starting at 13 years old, Ms. Mayancela was raped and sexually molested by a cousin bi-weekly. She became pregnant at 16 from the rapes. That alerted the family to what was happening, and Ms. Mayancela's mother reported it to police, but they didn't do much, and it only made the cousin more aggressive. The cousin fled before police could get him, but only after some serious threats to Ms. Mayancela. Then he returned years later and continued his threats, even with a knife and often drunk and even trying to abduct the child. Ms. Mayancela escaped to the United States in 2010 but was removed. When she returned to Ecuador, she met her current husband, the neighborhood milkman, and had children. And she again fled to the U.S. in 2016 after another threatening incident from the cousin. She returned back to Ecuador in 2021 to get her children and re-entered again. So I guess 3 unlawful entries. Her husband, Mr. Santander, is also indigenous and was involved in a political party that advocated for indigenous Ecuadorians. At one protest with the political party in 2014, he was attacked by members of an opposing political party with metal rods. They were wearing military garb. They threatened to kill him if he kept up his political activities. He also received threatening phone calls. Police said that they couldn't help him because he lived, quote, too far away, end quote, in the indigenous community and suggested that he flee the country. So he did in 2015 for America. An immigration judge denied the family's consolidated claims, though finding them credible. Mr. Santander's asylum application was untimely. For example, although Ms. Mayancela's was not due to her 2021 reentry. On the merits, though, the immigration judge pretty much denied on many asylum elements and withholding of removal for both Mr. Santander and Ms. Mayancela. Convention Against Torture denied too. The IJ concluded that Mr. Santander had suffered past persecution on account of his political opinion, though, so that's a big win. But remember, the asylum application was untimely. On withholding, the IJ concluded that the government had established that circumstances had changed for Mr. Santander in Ecuador, rebutting the presumptively well-founded fear. Ms. Mayancela's claim was denied in large part based on nexus, and the BIA affirmed all the denials, focusing on the lack of nexus for Ms. Mayancela. To the BIA, it was just a generally, sexually, and otherwise violent, horrible, creepy, drunk cousin. And yes, the BIA affirmed on changed country conditions too, finding that Mr. Santander no longer had a well-founded fear. So no wonder this is such a long decision, right? We're essentially doing two separate asylum claims at once. And in its long decision, the First Circuit remanded. Starting with Ms. Mayancela. The court didn't believe that the BIA and the IJ conducted a proper mixed motive analysis on nexus. Yes, the cousin is a violent, gross, horrible drunk. But might one other central reason for his actions be on account of Ms. Mayancela being an Ecuadorian woman or Ecuadorian female? Maybe. Quote, just because the agency finds that persecutors were motivated by a non-protected ground does not end the inquiry, end quote. And this despite the IJ ostensibly considering these other nexuses to a protected ground. The IJ's actual analysis, despite the words used, tells a different story to the First Circuit about what the IJ actually considered. The IJ, quote, did not engage with the evidence, end quote, or explain how or why Ms. Mayancela's, quote, sex and gender were incidental, tangential, superficial, or subordinate to the cousin's motivations deriving from his violent disposition, drug use, or alcohol, end quote. Gotta do it. Two things can be true at the same time. Instead here, it seems that the IJ kind of cherry-picked Ms. Mayancela's testimony and quickly concluded that a non-protected reason was, quote, solely, end quote, responsible for the cousin's actions. Can't do that. He can be a sexually deviant drunk and have targeted Ms. Mayancela on account of her being an Ecuadorian female, for example. The cousin's own words indicated that he thought he had a right to Ms. Mayancela because that's what was expected of Ecuadorian females. And the expert and United Nations evidence of record supported this. Importantly, the First Circuit does, quote, not require an asylum applicant to demonstrate that she was singled out only due to her protected trait, end quote. The BIA and the IJ would and did kind of hold that here. They relied on matter of MRMS, that somewhat astonishingly decision issued by Attorney General Garland's BIA last year, if I'm not mistaken. In a footnote in this decision, the First Circuit makes quite clear that neither that decision, MRMS, nor the out-of-circuit precedent since applying it bind in the First Circuit. A persecutor in the First Circuit need not be trying to overcome the protected ground or have animus towards the applicant's protected ground for the applicant to qualify for asylum. Matter of MRS has, quote, been definitively rejected by this circuit since the agency's decision, end quote. That's Pineda-Maldonado v. Garland, episode 196. If any listeners are paying attention in New England and Puerto Rico. Adding to this error, the BIA, in the First Circuit, must apply de novo review to a no-nexus finding, and it appears that the BIA did not do so here. No small holding, or near holding, by the First Circuit practitioners. Don't get me wrong, they might not succeed on remand, but a remand it is, nonetheless, for proper analysis. And I think that means that as a derivative spouse, Mr. Santander essentially gets another shot at asylum too? I believe. Even though his own direct application was untimely. I believe. Check me on it. Pretty important though here too, because the First Circuit affirmed denial of his separate claim. Recall, his issue is about DHS meeting its burden to show a change in country conditions, which it seems that the IJ and the BIA deemed met primarily based on the fact that President Correa is no longer, well, president, along with some political changes at the local level in Ecuador. And remember that for DHS to meet its burden when past persecution has been shown as here, quote, abstract evidence of generalized changes in country conditions without more cannot suffice, end quote. The evidence must negate a petitioner's specific experience and fears. But it was sufficiently done here, said the First Circuit. Quote, here, the agency plainly considered more than just shifts in national and local political appointments in its determination that circumstances in Ecuador had fundamentally changed since Mr. Santander suffered persecution for his support of the Pachakutik party, end quote. Political changes at the national level don't likely suffice in the First Circuit due to a few cases discussed recently on the podcast when DHS has the burden on changed country conditions. Even though I imagine that evidence of high-level changes are more persuasive for directly political cases. But in any event, the agency did more here, said the First Circuit. The decision gets into the nitty-gritty of Ecuadorian politics, which I shall use my discretion to spare you all. On to Convention Against Torture then, for both individuals. Seems like the First Circuit doesn't see government acquiescence in either claim. But make sure you actually present cat-specific arguments in your briefing, because it looks like the petitioners did not do so sufficiently here. Quote, when petitioners attempted to piggyback on their asylum arguments to avoid the required meaningful examination of the distinct elements of their independent cat claims, that amounted to waiver, plain and simple, end quote. Though I guess that goes the other way, right? If an IJ or the BIA does not give distinct analysis of a cat claim, that amounts to waiver? Anyway, cat denial affirmed here. But again, Ms. Mayancela is getting another asylum shot, which I think Mr. Santander can benefit from. So congratulations, Kevin P. McMurray for petitioners. Big case. And that is Mayancela Guaman et al. V. Bondi. Are you fighting like a maniac, completely overwhelmed by the chaos of the new administration? Immigration policies are shifting fast, the pressure is piling up, and clients are desperate for help. You're working around the clock, but there's only one of you. Well, Staffy's got your back. Staffy's bilingual virtual paralegals and administrative assistants handle USCIS forms, client intake, evidence gathering, and scheduling, so you're not drowning in paperwork while trying to fight for your clients at the same time. Stop running on empty. Staffy gets you a trained, ready-to-go team fast with HR-backed support, onboarding, and continuous training. You don't have time to do it all alone, and you don't have to. Schedule a consultation at staffy.cc, that's stafi.cc, and claim $500 off your first month. Concluding with two from the Fourth Circuit. The first one, Ibarra v. Bondi, published by the Fourth Circuit on April 29th, 2025. This case is about good moral character. And I see you listed in the decision on the paper as Oil's law student intern. Pretty cool honor. Mr. Ibarra is from Mexico, has lived in the United States for a long time, and applied for non-LPR cancellation of removal in immigration proceedings, alleging that his 4 U.S. citizen children would suffer exceptional and extremely unusual hardship if he was removed. The problem is that he had been using the stolen identification of a U.S. citizen for years to not only get a social security number, but to, quote, buy a house, secure a mortgage from a bank, and obtain homeowners insurance, end quote. When he was caught, he pled guilty to illegal entry to resolve those charges in criminal court, But the facts alleged remained, I suppose, and he never claimed that he didn't do it. Indeed, during his hearings, Mr. Ibarra's, quote, attorney twice attempted to assert the Fifth Amendment privilege against self-incrimination on his behalf. But these objections were overruled, and Mr. Ibarra continued answering questions without asserting the privilege himself or asking to consult his attorney, end quote. How can I not address that? Non-citizens absolutely have the right against self-incrimination, although I believe the regulations, or at least case law, permit IJs to draw a negative inference from their doing so, unlike in criminal court. But here the IJ's overruling kind of seems correct, because there's no risk of Mr. Ibarra being prosecuted for the false ID stuff, right? It was already resolved. It would be double jeopardy, as the prosecution dropped the charges in the past, it seems, as part of the plea deal. Sneaky, sneaky. Anyway, the IJ used the finding that Mr. Ibarra lacked good moral character during the 10 years predating his application to deny relief under INA Section 240A(b). And that good moral character statute is the catch-all provision in INA Section 101F. The BIA affirmed that, as did the Fourth Circuit. To the court, this is a mixed question of law and fact. That is, whether settled facts meet the legal good moral character standard. That makes it reviewable after Wilkinson and Guerrero-Asprilla, etc. And I could have sworn that that makes it a question of law that the circuits review de novo. But this is now the second week in a row where I've been told otherwise by the judges. Quote, this mixed question is reviewed for substantial evidence, end quote. I don't get it. I really don't. Like I truly don't. But as I have often had occasion to note, I am not a judge. Applying that standard, the Fourth Circuit didn't have difficulty affirming the agency. Fraud's a CIMT, explained the court, and while that's not the direct reason for the good moral character denial here, it shows why the multiple frauds evince bad moral character, even with all the positive aspects of Mr. Ibarra's life. You don't need a conviction for the good moral character catch-all provision at INA Section 101F. As also so often occurs, I guess I was a little too early on my Fifth Amendment postulating, because the Fourth Circuit addresses the issue directly later on. Seems like actually it was the attorney asserting the Fifth Amendment, but Mr. Ibarra kind of ignored his attorney and testified to the fraudulent conduct anyway. He had to assert it himself, not his attorney alone, and he certainly can waive it. That alone bars him from asserting the privilege now, explains the Fourth Circuit. Flat out, lawyers cannot assert the Fifth Amendment for their client. It's, quote, personal to the witness himself, end quote. Now, attorneys can speak up and advise their client to plead the Fifth, as I have done, but also, as has occurred to me, the client, prepared on that very issue beforehand no less, can ignore their attorney and testify anyway. Quote, to be sure, Mr. Ibarra's counsel tried to get him to exercise his rights, but the client must invoke those rights himself. Counsel's invocation does not count, end quote. The Fourth Circuit kind of addressed what I mentioned above in a footnote, but it wasn't actually dispositive, so take what I said with a grain of salt. I personally believe I'm right, though. But I will plead the Fifth if challenged. And all of it means that Mr. Ibarra remains ordered removed. And that is Ibarra v. Bondi. Let us please conclude with Baptista v. Bondi, published by the Fourth Circuit on May 1st, 2025. This case is about aggravated felony theft offenses. And strap in, put on your wonky hats, because we're going for a ride. Mr. Baptista is from Cape Verde. He became a lawful permanent resident in 2005. He should have naturalized. Over a decade later, he was convicted in Massachusetts State Court of unarmed assault with intent to rob or steal. That's Massachusetts General Law, Chapter 265, Section 20. The IJ and the BIA concluded that the crime was an aggravated felony attempt to commit an aggravated felony theft offense under INA Section 101A43U and G, making Mr. Baptista removable and ineligible for most forms of relief. And the Fourth Circuit affirmed that. Categorical approach applies, of course, meaning that we first need to know the generic federal definition of theft. Because in large part, whether a conviction matches a Section 11843U attempt to commit any other aggravated felony depends on whether the attempt, if completed, would match the definition of the underlying aggravated felony. Here, theft. Among other things, that definition requires, quote, taking to be against the victim's will, end quote. So takings through a, quote, victim's fraudulently obtained consent, end quote, don't cut it. Restated, fraud crimes are often not theft aggravated felonies, and that is an important argument to remember. Mr. Baptista argued that this Massachusetts statute is such a crime. But it's not, said the Fourth Circuit. Let's turn to the Massachusetts statute. It reads, quote, whoever, not being armed with a dangerous weapon, assaults another with force and violence, and with intent to rob or steal, shall be punished by imprisonment in the state prison for not more than 10 years, end quote. Nothing about fraud there, right? Well, what does stealing actually require? Posited Mr. Baptista. Really, argued. See, at common law, larceny and fraud crimes were separated. But in modern times, most states have evolved to bring all types of takings, even through fraud or embezzlement, under the umbrella of theft. Quote, Massachusetts has adopted this approach. Its larceny statute reads, and now quoting that, quote, whoever steals or with intent to defraud obtains by false pretense, or whoever unlawfully and with intent to steal or embezzle converts the property of another shall be guilty of larceny, end quote. And end quote again. That's Massachusetts General Law, Chapter 266, Section 31. That all very much supports Mr. Baptista's arguments, and it's confirmed by the Massachusetts Supreme Court, no less. That is, larceny in Massachusetts seems to include fraud-type conduct. The problem is, to the BIA and the Fourth Circuit here, the statute that the Massachusetts Supreme Court decision interpreting is about larceny. What we have here is a different statute, unarmed assault with intent to rob or steal. Steal doesn't necessarily mean Massachusetts larceny, explained the Fourth Circuit. For one, this statute appears in the Massachusetts law section next to things like murder, assault and battery, and armed and unarmed robbery. So it's not in the theft-type section of the Massachusetts laws. To the court, then, the robbery statutes in particular are pretty analogous, as they refer to stealing in the same way as Mr. Baptista's statute does here. While there aren't any jury instructions for this specific crime, there are for robbery in Massachusetts, and they expressly require a finding that the stealing was against the victim's will. You can't be convicted through fraud or embezzlement-type conduct, that is, for Massachusetts robbery. Also to the Fourth Circuit, quote, the unarmed assault statute's requirement of force and violence makes the crime impossible to commit with the victim's consent, end quote. How can you use force but also use fraud? Doesn't make sense to the Fourth Circuit. After committing more detailed analysis than that, of course. At the very least, the force required in Massachusetts requires a showing that the victim be placed in fear, even if to the court the specific crime can be committed with the perpetrator being unarmed. Restated and in conclusion, excellent job, Oil, getting the Fourth Circuit to bite on the argument that Massachusetts robbery is the appropriate analogous statute rather than, say, larceny. The Fourth Circuit explains how its decision here aligns with the very similar decision Kamukai v. U.S. Attorney General out of the 11th Circuit on episode 180. So the Fourth Circuit believes that the completed offense would be a match to the federal generic definition of theft for the aggravated felony provision. But remember, we have an attempt-type aggravated felony allegation, meaning we're not done yet. The categorical approach also applies, quote, for the attempt itself, end quote. That is, Massachusetts attempt must also match the federal generic definition of attempt used at INA Section 11843U. In analyzing that argument, first, the Fourth Circuit rejected the argument that INA Section 11843U, quote, refers only to an offense that a state has labeled as an attempt, such as a general attempt statute prescribing the attempt to commit the completed offense described in other provisions, end quote. The aggravated felony statute for attempt can instead include completed offenses that are similar to attempt when completed. So this isn't actually about Massachusetts' general attempt. This is about only this completed offense. Kind of attempt analogous, but analogous enough. That is quite the holding out of the Fourth Circuit. That is, that things beyond mere attempt can still meet the INA 11843U definition of attempt. Remember this argument for other circuits, though? Although it seems that the Second and Seventh Circuit may have already rejected it, maybe others. The Fourth Circuit also rejected, quote, Amicus Curiae Legal Aid Justice Center's argument that the BIA's view improperly conflated intent with attempt, which unduly eases the burden on DHS to establish removability, end quote. The Fourth Circuit does not share these concerns and others from Amicus. Then, citing to the Ninth Circuit, the Fourth Circuit explains that the federal generic definition of attempt in the theft context at least requires 1, an attempt to commit a theft offense, and 2, an overt act constituting a substantial step towards the commission of the offense, end quote. The Fourth Circuit held that the crime here satisfied those two elements. If you haven't gathered already, it's a complicated decision, but essentially, here, on attempt, the Fourth Circuit rejected Mr. Baptista's reliance on a 1975 Massachusetts Supreme Court decision and held that, quote, because a victim must always be at least objectively afraid of bodily injury, even in the threatened battery form of assault, there must be an overt act causing such fear, end quote. Meaning that you always need the overt act requirement under Massachusetts law, explained the Fourth Circuit. So for this offense, you have a match to INA Section 11843U, attempt. Rejecting some more arguments, the Fourth Circuit affirmed removability. Man, the categorical approach can get complicated with smart attorneys, no? And I must note, before we go, honestly, this whole analysis would likely be irrelevant if Oil had argued, or if the Fourth Circuit believed, Attorney General Barr's decision in Matter of Reyes, Episode 14, was correct. But to my knowledge, Oil's not touching that decision, and no circuit has affirmed or really even taken up that wacky case. But of course, we're only at the beginning of Trump 2. And that is Baptista v. Bondi. So there you have it. You're all caught up with the past week's published immigration cases. I'm Kevin A. Gregg, a partner with the law firm Kurzban, Tetzeli, and Pratt, and this has been another episode of Immigration Review. Thank you for listening, and I hope you enjoyed it. If you did, please share it with a friend and rate and review us. Each review helps new listeners find the show. And of course, subscribe to Immigration Review wherever you get your podcasts. If you like what we do and want to become a patron of the show, please check out our Patreon page at www.patreon.com/Immigration Review or click on the link in the show notes. And if you're interested in an official Immigration Review CLE certificate, email me at kgreg@kktplaw.com with your full name and the episode numbers for the 10 shows you've listened to. Also, feel free to email me with questions, comments, or anything at all, and follow the show on Instagram and Facebook at Immigration Review, or send us a tweet at ImReview, that's IMM Review. And you know, we're always interested in hearing listener feedback. Like this review about the episode you just listened to, from my very young son. Son, how did you like that episode? Indeed. If you, like my son, enjoyed what you just heard, again, please give the Patreon page some love, feel free to review the pod, reach out to me with your own kind sounds, or do anything else nice that your heart desires. I'll be back next week for a brand new discussion. Until then, I'm Kevin A. Gregg, bringing you the Immigration Review.